All right, well, good evening, everyone. I hope no one showed up in the classroom yesterday. I posted the notice, no class on Monday. But we are having class here. We're actually taping it on a Tuesday, and everyone will be reviewing the tape and getting credit for this class. A couple things. Number one, I've gone through all of the midterm papers, and as a whole, terrific job class. They were impressive pieces. I can say with certainty that you are all far more creative than I ever was when I was a junior or a third year or a fourth year in college. So I've gone through them. I've graded them. The grades are going to be coming out, I think, at some point next week. We're going to be submitting them today or over the course of this week. If you want to go over the midterm with me, by all means ask, and all you need to do is set up an office hour, and I'll be happy to sort of walk through and give you my thinking in terms of the grading. Okay, with that, I want to pick up a little bit on where we left off last week. Very clear from the takeaway notes that you all picked up on the substantive points that I was hoping you'd take out of it, which is really when we think about life sciences, it's relatively compelling and certainly superficially intuitive to sort of think, well, why are we going to patent anything that can be so valuable to patients, right? Why are we going to put the right to exclude others from exercising medical care in someone's hands? And all of you, I think, picked up on this point very well in the takeaway notes that, yeah, on one level, it makes sense, but when we start thinking that medical devices and pharmaceuticals require investment dollars, those investment dollars may not be very easy to get if what you propose to develop is going to be accessible to everybody in the world. Without any charge. So you all picked up on that. And I really do think that was one of the key takeaways. I think the second takeaway was what we learned from the ANDA perspective, right? The abbreviated new drug application process called the Hatch-Waxman Act. If you think about it, okay, from a generic standpoint, okay, the notion is create a drug based on something that has already been patented. It's not so much a design around. It is, and I'm overstating it a little bit or generalizing a bit, but by and large, it's not a design around. It's a copy. It's a copy. And the point behind the copying process is it's certainly okay to copy when the patent term comes to an end, right? The issue is, well, what about these patents that have been issued, and some of these generics out there think, they shouldn't have been issued. And that's where we have the whole Hatch-Waxman process where it makes it relatively easy for a generic to challenge the patent, or at least initiate a challenge, right, without the upfront dollars. All you need is a paragraph 4 certification, okay? And then in return for making it relatively easy for a generic to challenge the patent, okay, the brand gets the 30-month piece, if you will, right? There's a delay on the generics application. So that's the fundamental trade-off, right? And then we had the third piece of this, which is what's in it for the generic to take the lead and challenge. And the point there is you have the 18-month period of exclusivity that the generic will enjoy along with the brand, right? That's the duopoly we were talking about at the tail end. So those, and really, if you take it a step higher, the notion here is Hatch-Waxman is really an example of Congress effectively balancing these two competing policy interests, right? The one interest being let's get drugs to patients, okay, in a relatively inexpensive way, right? That's the one policy consideration. We all like that. But on the other hand, if no one has an incentive to develop a brand product, a brand drug, there's going to be nothing to copy. There's going to be nothing to deliver to the patient. So you need to keep that incentive to develop new innovative drugs as well. And so what you have with this, again, Hatch-Waxman Act is an effort to balance that. So that's the second key takeaway, I think, from last week. Okay, with that, enough from me, and let's, and I'm actually trying to think if there was anything else that I wanted to mention to the class. No, I think we covered it all. We're going to be back here next Monday, which is October 23rd, 6 p.m. And that's when we're going to have the two representatives from Nike who are going to talk to us about IP from Nike's perspective, and we're going to have a whole lot of focus on trademarks. Today, okay, the focus is going to be copyrights, and we are going to get into copyrights and how copyrights play a role in today's economy from the perspective of Hulu. And with that, I want to introduce A.J. Bedel, who is a counsel, an attorney for Hulu, and he will walk us through some of what Hulu does and some of the copyright issues that Hulu faces. So, AJ, with that, welcome.
Thank you.
And thank you. If the class were here, they'd all be applauding you wildly, but they're not. So we're going to have to. We won't have that. AJ, can you give the class some background about you and what it is you do for Hulu?
Sure. So I have been at Hulu about 2.5 years after working as an outside counsel for a number of years before that. And I really wear two hats at Hulu. One is I defend Hulu from any business litigation that comes up. And then I take care of our soft IP portfolio, trademarks and copyrights. And it sounds like I should probably watch your Nike presentation, because I could probably learn a thing or two from those Nike guys. They have quite the trademark. And so I work on a trademark and copyright portfolio stuff, but also enforcement actions and making sure that Hulu is walking the narrow path and the good path on their IP.
Okay. And I just, a note to the class, I think this came up when we were a couple weeks ago with Ms. Buckner from Dollar Shave Club, where she mentioned the soft IP word. And by soft, we do not mean that it's any less important or any less rigorous or challenging, if you will, than what we call hard IP. The reference to soft really is that when we think about patents, we're talking about core, technology, core engineering. Whereas when we talk about trademarks, copyrights, it's less, hardcore, if you will, technology. So it's not intended to be disparaging, and we all use.
I hope not.
No, you hope not. Right? We all use it in the trade, but I don't want anybody in the class to think about that. And in fact, the only reason I mention it is because I saw it in someone's takeaway notes. That was a question. Okay, with that. AJ, you want to walk us through what Hulu does?
Absolutely.
Okay.
And no more appropriate way to do this class than a video on demand, since that's primarily what Hulu does, is video on demand. So I want to give the class a quick introduction, in case you don't know, about what Hulu does, the history, and how we got to where we are today. I thought the best way to do it, since we are a video company, is to give you what we call at Hulu a sizzle reel, which highlights an event we had a couple months ago called the Upfronts, where advertisers come and hear about what Hulu has to offer for the upcoming year and hopefully entice them to buy advertising on our service. So let's take a look.
What if Hulu changes TV forever? Oh wait, What if it already has? Damn. Wouldn't that be cool?
Thank you for joining us. You know, one of the things I love most about Hulu is our history of pushing the boundaries of technology and entertainment. And we're not just changing the way you watch TV, we're changing how you experience it. We like to think of this as TV come true.
We're taking bigger swings in the stories we're trying to tell and are continuing to bring aboard the most unique voices in entertainment to help us tell them.
Thank you so much for having me today.
Wasn't that a lot of integrations?
They started shooting this morning.
I cannot wait for you to see what's in store. Thank you.
Hulu is where the best of TV meets the best of digital. In short, we've got the good stuff. From the content to the ads, Hulu is completely transforming. And on behalf of all the hooligans everywhere, I thank you for the opportunity.
All right. Hopefully that gets you a little bit excited to learn a bit more about Hulu, and I can't help but watch that video and think of all the different ways that IP touches on so much of what you saw. Trademarks in the name, the slogans, and certainly copyright on all of that, that content that you saw. So now I want to rewind the clock a little bit and go back to how Hulu was originally formed. And so that takes us back to 10 years ago in the middle of 2007, when originally this was a nugget of an idea at Fox, which was they kind of saw what I think of as the Napster problem, where they saw what happened with the music industry. And you know, Napster was kind of 1998, 99, 2000, where there was this digital revolution of consumption of entertainment. And as a result, iTunes kind of came out of that, where someone could go purchase legally, but via digitally, music in response to Napster. And so what Fox thought was, how can we do that for television? How can we get...
Let me just unpack that a little bit here, just so everybody in the class appreciates the issue going on here, right? So there was a point in time, and I think most of the students, I think some of you probably remember it, when the music actually came out on CDs, right? And then the problem with CDs ultimately became is somebody would take these CDs, the digital information on the CDs, upload that stuff onto an internet service, and then make the uploaded digital information available to anybody who wanted to download it.
Right.
It's what what's been called piracy. And so what AJ's talking about was, if we talk about iTunes, decided to basically sort of get ahead of the game and say, look, if we can't beat them at this, we're going to join them, and we are going to make the digital information available to the consumer off the internet, albeit for a fee.
Right. Okay. And join them really in the digital space.
Right.
And so Fox didn't want to like kind of lose that race to digitization when it came to their television products. And so they wanted a way in which users could get that kind of digital access to the television content that they're used to turning on their TV screens through cable, satellite, or even the old bunny ears off the air. But what Fox realized was that they couldn't do it alone. They needed someone else, because users were used to kind of experiencing all those channels together, right next to each other, right? And you're flipping the channels. And so what Fox ended up doing was looking around for another studio that would join them as a partner. And who they ultimately found was NBC. And the two of them created a joint venture, and that joint venture ended up being Hulu. Now, as we sit here today, it feels like Hulu's been around for 10 years. We recently won some Emmys. It seems like almost a no-brainer. That was not the case in 2007. So I found this news clipping that I wanted to share, and it's from August of 2007. This is a TechCrunch article, and it's where Hulu's being referred to as Clown Co. And it turns out, in an off-the-record conversation with a Google employee, Hulu was being referred to as Clown Co. because it was just a clown idea that they just did not think was going to take off at all. And part of that was, think about Google's perspective, right? You have these old studios, these old models trying to get into what they probably, I'm sure, thought of as their space, digital, and that would never be able to catch up with what was actually going on. Google had just purchased YouTube at the time, so they were getting into that space. And so, fast forward now 10 years, obviously Hulu's still around, not really called ClownCo anymore, except when we need motivation. So let's fast forward 10 years, and obviously we've been successful and still here, no longer called ClownCo, but the ownership structure has changed slightly. In 2010, Disney joined. Disney owns ABC, so now some of that content can be seen on Hulu. And then just last year, Time Warner, who owns the Turner Networks, Warner Brothers Studios, HBO, joined as well. So the current structure of Hulu are this for ownership as a joint venture, a partnership, and which they all contribute content and then benefit from the revenue as well. I thought it would be good, though, to kind of walk you through the various iterations that Hulu has gone through to give you a scope of where we are as a company and where we came from as well. So we began in late 2007, Hulu launched its beta service. So we just had people kind of log in and were the early users. Now in this early version, again, this is going back to, it's just Fox and NBC at this point, it was their content kind of from last night. And so you would have, let me see, for Fox back then, it would have been episodes of like Family Guy or Simpsons. But it wouldn't be the whole season, right? It would be the last 4 or 5 episodes of that show. And then from NBC, you would be talking, Law and Order SVU. And this would be a way that, let's say maybe you missed the show or you didn't DVR it, but you heard it was really good. You could go online for free, watch the episode, and then where there were ad breaks, if you had watched it on TV, Hulu would digitally insert advertising as the only source of revenue for Hulu as a service at the time. In May 2008, we officially launched, but continued to be a free service, no subscription service, no subscription needed. The advertising revenue, though, was the only revenue. That changed in 2010. We launched the product that we called Hulu Plus. And now there was a subscription associated with it. And instead of the 4 or 5 episodes of the show, we started to offer full seasons, or even for some shows, the entirety. And so we'd have older shows like A-Team and Golden Girls, and we would have, from episode 1, season 1, all the way to the series finale. There were, however, still advertisements on all those products. So what you were paying for is really more episodes, but it was still all ad-supported. And that opened up at a $7.99 per month offering. 5 years later, September 2015, Hulu finally launched its no commercials plan. And for the first time now, users would pay a little bit more each month, and then there were no advertising inserted into the content. And now in just last year, we finally said then goodbye to our free plan. So now you have to be a subscriber to access it. And then you have 2 options, though. You can subscribe as a regular subscription member with ads, or our no commercials plan. But we did finally remove the free option. And then just a couple months ago in May, and it was highlighted a lot in that video that you just saw, we launched our live service. We actually launched it at that event. And now we're kind of doing this skinny bundle cord cutting thing where 50 plus live channels, including CNN, all the ESPNs, all the Fox Sports, and getting into that world where right now I think there's a couple other competitors as well, but we're throwing our hat in the ring to be the skinny bundle of choice for any cord cutters, or as we like to call them, cord nevers, those who've never had a cable or a satellite package. So just quickly want to go through kind of what our current offering is. So you can see on the left-hand column, we have that old ad-supported, still that same $7.99 price, although if you go now, we have a special offer going on, $5.99, can't help but sell you on it. Comes with a 30-day free trial. Just give it a test before we charge your credit card. And there you get those old shows, like I said, the streaming library. You get some of our originals, like I mentioned before. We have Handmaid's Tale, which won the Best Drama Emmy just a couple weeks ago, along with a lot of other great originals. We have more coming up. And movies as well. We have a bunch of the Bond movies, Mission Impossible movies, a lot of great stuff there. And then you can add on HBO, Cinemax, or Showtime and get all of that content on demand. The middle column shows our no commercials. That's $11.99 a month. But then it's kind of all the same content, just without those commercials. And then finally, the live TV offering I mentioned, $39.99 a month, 7-day free trial, the channels, and you get kind of everything that's in that left-hand column as well, the entire library, the originals, the movies, and then a bunch of add-ons, including your HBO, Cinemax, and Showtime. And that's our current offering. And so where does IP come into play? Like any business, we patent our software innovation, and like any business as well, we trademark that Hulu logo, ad slogans, and certainly protect our domain name as an online business. It's very important that we protect the Hulu.com and related domain names. But then, and Luke, I know this is what you want to focus on today, is our copyrights, and that the touch point there is our content.
So, AJ, before we move on to the software stuff,
Sure.
the copyright issues, a question: what is it that, I mean, to sort of go back in time, right? The value proposition that Hulu brought to the table. Why not have? I mean, if the notion was to get ahead of not to get involved in the Napster situation and not let video, pirating get to that point and get into the digitation space, the digital download space first, that's the point. Why didn't these companies do this on their own, right? Why did Fox need to partner with everybody? Why would Disney partner with Fox, partner with NBC? And partner with, there was another one that
Time Warner.
With Time Warner.
Yep.
These are competitors.
Yeah.
I mean, so what are they doing? What are they doing together? Why not go off it on their own?
Right. It's a good question, and I'll be doing a little bit of speculating here, but my guess is what you might be seeing in what's going on right now is CBS, so somebody who isn't one of those partners in the joint venture of Hulu, has gone off and they currently have a product offering called CBS All Access. And that is a video-on-demand product of CBS shows. And they have some great shows, right? 60 Minutes, Big Bang Theory, a bunch of shows that a lot of people watch. But what we've seen from kind of user reaction to that offering is that people don't want to download 15, 20, 25 different apps and have your HBO app and your Fox app and your CBS app and paying its own subscription service for each one of those. So I think one of the value propositions that has been there from its inception, has obviously only grown as our ownership has grown, is that Hulu's a one-stop shop. And so you could get all of those networks offerings and their content, as well as HBO if you wanted, Cinemax, Showtime, and just you click on the one app and it's all right there. And so you can search for the stuff. Our recommendation can recommend, hey, you like these Fox shows, maybe you would like an NBC show, and all of that is right there versus having to remember, okay, that was on CBS, I need to open the CBS app, et cetera, et cetera.
Right, okay. No, that makes a lot of sense. Okay. This course is going to revolve around copyrights, so let's take a step back and go over some copyright fundamentals again, right? We all remember Diana Torres came in and gave us a terrific lecture on the fundamentals, but there are a few that I wanted to revisit today just to lay a foundation for some of the things that AJ is going to get into in terms of Hulu's day-to-day issues and challenges, and how software comes into play from a value proposition, or I'm sorry, I said software, I meant copyrights come into play as a value proposition for Hulu in the entertainment industry. All right, so back to basics here. What does copyright protect? Copyright protection is available for original works of authorship fixed in any tangible medium of expression, right? It has to be an original work of authorship that's tangible, all right? So, what else? What do we have by way of examples? Musical works, books, movies, plays, photos, artwork, computer code, website materials, advertising, packaging materials, and a lot of others. Okay, what does copyright not protect? Okay, there is a key distinction that everybody needs to keep in mind when we think about copyrights. Copyright protection protects the expression of ideas, not the underlying ideas themselves, okay? Ideas, the underlying ideas, are always, always free to use. And if you remember Ms. Torres, when she was here, she spoke about scenes of fare, where in the context, particularly in the context of movies, and it's just not limited to movies, you know, common elements such as you have the romantic relationship between a couple. You have, and I could go on and on and on, but she explained it to you. Those fundamental underlying ideas, okay, as opposed to the expression of the idea, are not protected, not copyright protected. Okay, one last point. Just because it took you a long time to do something, if it's not original, if it's not creative, it doesn't matter how hard you worked at it, you're not going to get the copyright protection. So you could, go up and down the street and spend a whole lot of time collecting, I don't know, house numbers and listing them, and spend gobs and gobs and gobs and gobs of time doing something like that. You're not going to get the copyright protection. Okay, everybody following me? Good. Oh, no.
What about in the case of, let's say, a musician creating a cover of another musician's song, and with some creative interpretation, so that you could claim that there's some originality to it, some creative input that went into creating this new version? How is that viewed in terms of copyright? Is there a new copyright that's generated?
AJ, you want to field that?
Yeah, sure. So music is unique, and I touch on it somewhat, but in my practice. But really with music, and I don't know exactly how it came about to be this way, but there are actually two copyrights in every musical work. One is the copyright that is in the music itself. It's really expressed through the expression of notes on a musical chart. The other way that a music is copyrighted is the audio recording of the performance itself. So when you do a complete cover of a song, you are actually free and clear of the copyright of the original artist's performance. But what you are making of, and if you don't have permission, violating, is the work of the notes on the page, right? Because you're replaying that song, albeit in your own way. And so cover artists and cover songs have to pay residuals to whoever created. And back in the 50s, you had these warehouses of people who just wrote songs. They didn't perform them. And then it would be the Motown artists would come in and perform them. So the guys who would write the songs would have one copyright, and then the Vandals, when they recorded it, would have another copyright in it. And if you covered the song, the guy who sat there and wrote down, you would need to pay him a residual, but not the Vandals.
Okay. So, what are the rights? And again, Ms. Torres covered this as well. What are the rights associated with a copyright? It's not just the right to have your work protected from having somebody make a copy. It's certainly one of them, but it's not the only one. It's a right to create derivative works. It's a right to distribute the copies. It's a right to perform the work publicly. And it's a right to display the work publicly. So all of those, are within among the bundle of rights that are associated with copyright protection. And as AJ is going to point out, when we talk, in this day and age, when we try to sort through these elements out of these bundles, it becomes somewhat challenging, given the technology that we're dealing with. So with that, Back to you,
Absolutely.
AJ.
So in thinking about copyright and how it applies to Hulu, the more I thought about it, the more it kind of broke down into 3 different categories. So I'm going to walk you through each of those ways that Hulu touches on copyright. And the first is a type of our originals. So I'm going to talk about 2 different types of originals that Hulu has. The first is a original created by Hulu. And those tend to be smaller budget projects, but at the end of the day, we wholly own all of the rights. And we actually, there is no Hulu Studios, but we hire a production company to make it for us. But at the end of the day, they don't own it. We wholly own it, and therefore have all of that bundle of rights that Luke was just talking about.
AJ, before we move on to the other types of relationships that Hulu has, let's still focus on the one where Hulu owns the entire work product. Does that implicate special issues with performers, if you will?
Oh, sure. So that is a situation where Hulu doesn't directly pay any of the performers or any of the, in front of the camera or behind the camera talent that makes those originals. That's the role that the production company holds. And so one way, if you don't mind, I'm going to use the whiteboard a little bit. So one way to think about it is that at the start of a project, please excuse my handwriting.
It's not worse than mine.
Is that showing up? All right. So in order to make a movie, a TV show, what have you, we have to have lots of contributors. So we have a writer, director, producers, actors, editors, and all of those contributors are putting their talents into a finished work. For a studio or a production company, and then the studio or the production company holds all of their contributions, puts it all together into the finished work, and then the studio and production company owns the copyright in that finished work. And then, typically the way it works is then the studio or production company finds a way to distribute it. This can get a little bit jumbled because there is an ABC Studios, and then there is ABC the network. So there are certain projects where all the contributors could contribute to ABC the studio, and then they just hand it off to their sister company, ABC, and the ABC network distributes it. So now I want to go back to that the scenario where Hulu owns the original. In those scenarios, all the contributors pour into a production company, and give it to Hulu as both a distributor, but Hulu's also then operating as the copyright owner as well. And
so who deals in that situation, AJ? Who deals with the guilds, right? We all know that the performers, the talents, are typically associated with unions and guilds and the like. Does Hulu deal with them, or is that done? How does that work?
That is done through the production company or the studio that makes it. But Hulu does not pay out those revenues or, if successful, those residuals to the contributors. So all the talent is flowing this way, but the money is flowing the opposite way. Let me see if I can get a.
And when you say Hulu doesn't, basically Hulu has a production company in place to deal with that.
We partner with all kinds of production companies. We don't have like an exclusive one that we work with. And so we have done deals with a number of different production companies for our originals as well as studios. So the talent is flowing kind of the black arrows, but the money's flowing the other way. So the distributor pays the studio and production company for the right to distribute it, in whichever way it distributes. We can get into that a little bit later. But then the studio and the production company pays each of the contributors going out that way. And that's part of what Hulu is paying for in the studio and the production company, is experienced doing this, knowing who to call on all these contributors, but also having the guild experience, knowing all the guild rules and those kinds of things. Whereas our specialty is much more in how to distribute it and then the revenues associated with the distribution.
So in the case, AJ, where Hulu owns its own, is the studio,
Yes.
if you will. Who owns the copyright, the original copyright? How does that work?
So in those cases, we have hired the production company. The production company does all of the making, but they are acting as, in a way, almost they are making this as a work for hire for Hulu.
Okay.
And that's how we ultimately hold the copyright in those originals. It's a small, but still significant chunk of the originals that we put out there. But again, those tend to be more of the low budget. And the example that I have in the slide there are documentary films or certain comedy specials.
Can you, and we had Ms. Torres explain that in one of our early courses, the concept of a work for hire. What is that?
Sure. So and the work for hire makes the most sense, I think, in the TV or film context because you have so many contributors, right? You have so many people who could, who contribute a little bit of their talents, but it's no one person. So what work for hire allows you to do is say, they were all working for you when you made it, but we need to assign one entity, the ultimate owner of the copyright, because we can't just have all of these pieces of copyright spread among all the various contributors and who contributed more and 10% versus 9%, and it would be a mess. So what they said was, this can all be a work for hire because the studio, the production company hires the contributors. But at the end of the day, the ownership of the copyright, the author of that copyright is the company, the studio or the production company.
All right, and what you're describing for the class is sort of generally speaking, and everybody in the class needs to understand that you have a lot of different particular situations depending on the agreements, depending on the contract. So you're sort of giving us what you often see, but not always. There are exceptions to what you've just described.
Yeah, there's always exceptions to a lot of this. One thing I did want to point out is, I keep referring to studio and production company together. Really, those are two terms for different size companies doing the same thing. A studio would be like one of the big studios that you might see in the name in front of a big film or MGM. A lot of absolutely. MGM's a studio, Lionsgate, Fox Studios, ABC Studios, Disney. Production companies are more independent. So production companies are standalone from a studio, and they just aren't associated with kind of those big. But the work they do can break down in the similar roles.
Okay. All right. You had a question?
Yeah. Are there cases in which there are multiple holders of the copyright? So Hulu might hold the copyright to a work in coordination with one of the studios that they do bring on work for hire?
Yes, it's incredibly rare, but it's funny that you bring that up because one of the examples that we're going to get to here in a little bit, actually we can just jump right to it. So the second copyright touch point that I have is a Hulu original from a studio, where the studio though maintains all of the rights except the right to distribute in the US exclusively. And those do tend to be where our big budget, big name originals. For example, Handmaid's Tale, Difficult People, I Love You, America. And so some of those relationships, it's 100% with the studio.
I Love You, America, by the way, premiering.
It's coming out in 2 days. So by the time you see this, it'll probably have premiered. Sarah Silverman, very funny, topical, political, edgy. All words you like to hear as the attorney for these projects. But the rights bundle can be broken up like that, and an example is Handmaid's Tale, where MGM, and this was just a deal that we made with MGM because Handmaid's Tale was a little bit different in that Hulu did a lot of the work packaging that up, and we had we got the book rights, we had the idea, and then we went out to studios and said, who wants to make this for us? And studios love that because it's already packaged and ready to go. And so in return for us doing that work, Hulu actually has a 25% copyright ownership in Handmaid's Tale. MGM owns 75%.
You made an interesting point before class, AJ, and that was we walked the students through all the bundle of copyrights that you have, and I think your reaction to seeing them was there was a day and age when it was really a lot simpler, particularly when we're dealing with books or more rudimentary, if you will, types of platforms. But when we're dealing in today's day and age, it gets more complicated. And you mentioned to me a way that you all deal with that complexity.
Yeah, so I mean, I kind of laugh when I look at the bundle of rights because I see that list quite a bit, but it rarely applies to the work that I do. Those rights were defined, I believe, in the 1978 Copyright Act. And so you think about where we were with entertainment in 1978, you have pressing of records and you have, physical books being sold. And so all of those rights make sense, right? A copy is different from a distribution, is different from like a theater public performance. The problem is when I think about our business and try to apply those terms to what we do, we need a lot of those rights. Because in a digital distribution of a video, so we're here in Santa Monica, and this is where we ingest the content. But if somebody's watching that content in Miami, Florida, we don't just have a direct line from here to their living room in Miami, Florida, and send it. In order to make it as quick as possible and as easy as possible for people to watch, we have little nodes throughout the country. But in order to get the copy to the Miami, Florida node that this guy's going to watch it on, it needs to be copied a lot. It also needs to be transmitted a lot. And in a way, you could argue it's also being publicly performed once it finally gets there because anyone in the public could be watching it. So those are three rights that we need, and we need to do quite a bit to make one digital distribution of a piece of content. And so in our contracts, you don't see a lot of references to exact rights that are given when a piece of content is licensed to Hulu. Instead, what we do is result-based drafting. And what I mean by that is we hereby give Hulu the exclusive subscription video on demand right to distribute this content and all copyrights needed to make that work. So it's a result-based statement in the contract rather than trying to figure out how these old 1978 categories apply to digital distribution. And it's also easier for those negotiating it, right? It's rare that I am in the room when these things are being negotiated, so we don't have a copyright attorney, but we do have is a bunch of people in the room who know what they want to get at the end of the day. We want to get those distribution rights, and we want to make sure that it's clear to our partner where and when and how we can distribute that content, and that's how you get those result-based phraseology in the contract.
Very helpful.
So we have Hulu Originals, so we have kind of two ways, one in which we own them and one in which the studio owns either in whole or, as you pointed out, in part, the copyright. The final copyright touch point I wanted to get to is content that we license but is already done. So it's not a Hulu original, but it's maybe broadcast on Fox or NBC before, or just has existed elsewhere. And we kind of refer to that around here as our library content of rights. And the examples there I have here, Family Guy, Seinfeld, big shows that you have seen but likely have had the ability to see elsewhere. And you think about the history of Hulu, that's how we started. We didn't get into the original game until 2010. But that's just another way that content comes onto Hulu and the copyrights that we need in order to distribute that content.
Okay.
And I think with that, I'm going to hand it off to you to go over fair use.
All right. Thank you. So when Ms. Torres was here, I think everybody in the class recalls we touched on fair use. And I know that it's a concept that everyone in the class has heard of. And what I wanted to do was turn to AJ's experience to walk us through this concept of fair use. Let's take a step back. What is fair use? Fair use, it's now enacted in legislation, right? But it was long recognized that there are instances where it is only fair, right, and right for the public to be able to access someone else's work. At some point, the interest, okay, that lies in, or the policy, if you will, that lies in encouraging someone to create something, okay, sort of cedes, if you will, to the public's right to learn. And this overarching concept of public access to knowledge, all right? And fair use comes in and tries to balance, to balance those two competing interests. Not unlike, I mean, it's the analog, if you will, that we saw last week, right, on the life sciences, where you have a Hatch-Waxman, and what we're trying to balance is this notion of getting cheaper drugs to patients, right, with giving the branded companies who are developing these new drugs an incentive to make the new drugs and get a fair return on the investment that goes into that process. So this is, again, somewhat of a balancing act, although, different policies, of course. So what do we have in terms of fair use? Well, the one concept we have is transformative use, right, where you take an original and you basically you transform it. You deviate from the original in some respect, okay? And whether or not a transformative use, okay, translates into a fair use turns on four factors, all right? The first one is really the purpose and the character of the use. Why are you taking this copyrighted material? And by the way, let me take a step back. Fair use is a defense to copyright infringement, okay? My point being is that you acknowledge that you've copied something. Now, the question is, okay, but I'm allowed to copy it by virtue of the fair use doctrine, okay? So we're no longer debating whether or not something was copied. We're beyond that. It was. The question is it fair? All right, so the first thing is the purpose and character of the use. Look, as a rule, and AJ, jump in if you feel you want to expand, or because as a rule, if your use is commercial, okay, odds are that a court is going to rule that, hey, it's not fair use. Now, exceptions to that, right? If we talked about the Saturday Night Live example, where Saturday Night Live is has a parody of Jeopardy or something like that. Is that commercial? Yes, it's commercial. But generally speaking, if the notion is we're going to make some money off of this, courts are going to take a closer look at whether or not this is really fair use. Flip side of that, and that's actually the second point here on the slide that you're looking at, if it's used for educational purposes, the odds are that you're going to get a pass. Not always the case, but those are the odds, okay? The second point here is the nature of the copyrighted work. The closer that the work that you're copying comes to factual material, okay, the more likely that a court is going to give you a pass on the fair use doctrine. As you move away from facts, okay, copying factual work, and you're moving closer to something that's fiction or more fundamentally creative as opposed to factual, okay, it's gonna get tougher to establish the fair use. Is that?
Yeah, I think that's fair.
Generally speaking.
Yeah, absolutely. There is. We talk about this sometimes when we're working on a documentary. Is that there is no established right to a story of what happened. And you've seen that. A nice recent example is last year you saw these two major O.J. Simpson projects come out of the blue. One was a fictionalized show on FX, the other was a documentary done by ESPN and ABC. Neither had the exclusive right to tell the O.J. story. And in fact, if you'd seen them, they're told in very different ways. And so there is no copyright, and it kind of goes back to that idea expression that you talked about earlier, is that there is no exclusive right to a singular idea, but it's just the expression of that idea. And so in the O.J. Simpson, like, everyone can try to tell the O.J. Simpson story. You're going to maybe go at a different way, or if you're a documentary, maybe you only have access to certain people who will talk on camera, and that'll affect how you tell the story, or maybe you take a different slant, but you can't lock up a historical fact.
Okay. The third concept.
You sometimes hear the term like life's rights and,
Yep.
and creators trying to secure that and to be able to tell that story. How does that figure into what you guys just described about not having the ability to exclude someone from telling something that happened in history?
So life rights isn't necessarily a copyrighted IP. It's something else. It's like the trade secret is also another one that I think of as kind of a gray IP area. But you can have a life right, and certainly studios or companies that want to make a film about somebody's life would go after the life right from either the person themselves or maybe their estate. But you also see a lot of unauthorized, and so there is still a way to tell those stories. It just is not in an authorized manner. And you often see, right, maybe not lawsuits, but threats or things put in the press about not being happy with an unauthorized telling of someone's story, which would not have happened if you got the life rights. But in practice, with those rights come from the limitations of, that person normally getting also the ability to say, well, wait a minute, that doesn't put me in quite the light that I want to be portrayed in this film about me.
No, right. And I just, as a complete aside, I think I picked this up in a paper, the Jimi Hendrix life story in the movie, where the concern on the part of the Hendrix family was portraying Jimi Hendrix in a way that many do, which means associated with some unsavory things, and that whether you agree with it or not, detract from the brilliance of the person. But I remember reading about that when the movie came out.
Yeah, I mean, and when you're putting a documentary together, there are a number of times where you just say, we're making this. And if you want your voice to be heard, or if you want that, then come on board, get on board the project, and it benefits the company making the documentary or whatever the project is, because you get that additional access, but it benefits them because they have a little bit more control over how that story is being told. And sometimes the scarier thing than having a film made about you is not having control of a film made about you.
No, and actually it's coming back, right? Because the Jimi Hendrix situation, what you had was a situation where the movie was not entitled to use, I want to say, actual recordings. I don't know if my memory's right on that, but that's that was the issue. The family wasn't going to come on board, and so some of the copyrights associated with his works weren't going to be accessible to the ones who came out with the movie. But go back and read about it, and then you can tell me whether or not my memory is on or off. Okay.
One more question about sort of, and maybe this is just terminology, but educational versus sort of informational. When you talk about documentaries, and is every documentary sort of seen as a educational medium, or is it? Do you guys distinguish between those two? Because there's some, implications for fair use, right?
Right. So we rarely use the educational use because no matter how educational our documentary is, we're not giving away for free. There is a commercial prospect to that. You're paying a subscription. We're paying the studio to make it. All of that stuff is made. So educational is really much more limited to in the classroom use of things. And as a for-profit business, we really couldn't take advantage of the educational fair use.
Yeah, and if you look, for example, at the Michelson Foundation, the 20 Million Minds, and the textbooks that are being available, and the links that are being made available, I mean, that really falls under the narrower category of educational, right? I mean, these books are not out there to entertain, if you will, and it's really not a commercial venture. The third piece of this is of fair use is how much are you using? all right? And we're going to get to some examples that AJ came up for us. But, you know, it stands to reason that the more you use of the original work, the more likely that you are not going to get a pass on fair use. The less you use, again, the more likely that you are going to fall within the fair use piece of this. And you find this in newspaper articles or magazines that preview books that are going to come out or that actually review books, right? I mean, a review is sort of a classic case of fair use. But if the review, if the review now becomes basically a substitute for the book, you're inviting some issues. So that's the third concept involved. And then the fourth one here is the effect of the use on the original material, and courts are going to look at that. Interestingly, we have to get the vocabulary right? Because if you have, for example, a movie review, right? A movie review can have a devastating effect on the movie, right?
Sure.
And if the effect is the standard, you know, if it has a large effect on it, then bad reviews would never fall under fair use, right? Well, that's not what we mean by the effect. What we're really talking about is the effect of the transformative piece, okay, from a competition standpoint, if you will, on the original piece. So that's what we're talking about. Okay.
Right. It's you know, would the copy substitute me buying whatever the original, you know, copyright was? And so you know, you know, I mean, just to go into my sphere since that's where I'm most comfortable, but are what is being copied here, is that enough that they wouldn't even click play on the show, right? And so you could see a circumstance where you have some of the shows that you watch start out with a like previously on. And if somebody just decided to go ahead and make their own previously on and clip together, you know, that would have a tremendous effect of the use upon the market, right? Because literally what's trying to be expressed there is, in case you've forgotten or in case you didn't see, here are the important points from last week's episode or last 3 weeks' episode. That would have a tremendous effect on the use because now you're not clicking or purchasing or watching those previous episodes.
Okay. No, that's very helpful. One important point, and AJ is going to get into this, is that there is no bright line rule. And I think this has been a consistent, if you will, mantra of mine in this course, which is when we talk about law, particularly in the area of IP, finding clear lines can be a challenge. More often than not, you're operating in a situation where we're talking about shades of gray here, and that, you know, on the one hand it makes it awfully exciting and fun to be a part of, but if you're somebody who's really into black and white, be careful, and AJ is going to explain that here in a second. I'm turning this over to you.
Sure. I mean, I'm glad there is no bright line rule, because not having a bright line rule gives me a job and to help sort through. And one thing I want to touch on before we move away from this fair use slide is that it is one of the more often used legal concepts around Hulu by non-lawyers. Everyone kind of has their idea about fair use and what they think they can copy. And so it is something that I deal with on a day-to-day basis in advising business people really on how to apply fair use. I did also want to comment quickly on the purpose and character of the use. I love the Saturday Night Live example for two reasons. One, it's comedy. So that kind of parody helps transform. And then the other is, so oftentimes Saturday Night Live is political. And that's another area that fair use gets to protect. You know, fair use stemmed from the First Amendment, free speech. And so political, comedy, those tend to have a lot more leeway with copying what you can and can't do because of the freedom of expression that comes with the First Amendment. And when I'm trying to put the fair use in practice, I focus a lot on transformative. Has the work been changed? are you adding to the dialogue, or are you simply copying what has been done before to take advantage of someone else's work? So I do want to go to an example. This is a real life example that came to me on a Friday night, because of course every tricky one comes on a Friday evening. But marketing, we had an original a couple years ago called Deadbeat. And marketing wanted to put up this, we call it key art, but basically it would have been the main poster for for Deadbeat for the new season. And just to give you a little bit of background, the main character there in the center, there are two main aspects you need to know about him. One, he smokes a ton of weed. And two, as a character, and two, he sees ghosts and helps ghosts with their problems. And so with the marijuana, you get the budding bromance reference. And then, of course, we had to premiere the new season on 4/20. And then he also deals with ghosts. And so this poster is taking off the old movie Ghost, made by Paramount Pictures, I want to say 25 plus years ago now. And the famous scene where they're making clay in the wheel, and spoiler alert, he's dead, and he's a ghost who's actually helping her mold the clay. Very, very romantic. And so the question was, is this fair use? Is our creation of a poster that is clearly evocative of that scene a fair use, or is it something that we need to go to Paramount Pictures and get permission to look at? So I wanted to raise two cases and the decisions made in those cases before actually tackling the analysis on this example. So the first example is on the left-hand side is a very famous Vanity Fair magazine cover of Demi Moore, taken by the famous photographer Anne Leibovitz. And on the right is the poster for Naked Gun 33.5 with Leslie Nielsen's head on Demi Moore's body. And this case went all the way up to the Second Circuit, so the circuit right below the Supreme Court and federal court. And the question was, is this copyright infringement? Or is this fair use? And what the court found here was that it was transformative, and that there was they're poking fun at this, the beautiful female form that was being shown in the Vanity Fair, and the seriousness of it is transposed with the comedy of the Naked Gun series and Leslie Nielsen in that role. Now, if I was Anne Leibovitz's, I would have said, wait a minute. You're taking 3/4, if not more, of my picture. It's obviously the exact same picture. I mean, it's the same hand, it's the same ring, it's the same everything. And so that you should have licensed that image from me. He's simply copying what I already did when I took the initial photograph. And keep in mind, it was Anne Leibovitz, the photographer, who is suing here because she was considered the author. For a photograph, it is the person who takes the picture. There's a recent case that got into some very fine points of copyright law where a monkey took a selfie and then handed the camera back to the photographer, and PETA sued and said that photographer doesn't own the picture, the monkey owns the picture. Ultimately, it was held that a monkey cannot own copyrights, but sorry, a little bit of an aside from my Anne Leibovitz. But like I said, the court ultimately held that this was funny, parody, transformative, allowed. The next example is again another movie poster. So here on the left, you have the poster from Men in Black, protecting the Earth from the scum of the universe. On the right is the parody of Michael Moore parodying the poster for his real documentary, The Big One. And then he put the slogan, protecting the Earth from the scum of corporate America. Now, Luke, I want to bring you in here on this one. When you saw this example, what was your initial reaction?
My immediate reaction was fair use.
Okay. So I think the argument for fair use is Michael Moore is generally known as a comedian. documentarian. Instead of a gun, he holds a microphone. That is his weapon. And the subject matter of that documentary is corporate America, so protecting the youth from the scum of corporate America. So I get where you're coming from on the fair use. I think Men in Black's argument would say he just copied our idea. Like, all he's trying to do is get people to see that, think Men in Black, and it's a popular movie at the time, and take advantage of all of that goodwill. He's not really adding anything to it. And I'll tell you what, the court actually sided with Men in Black, and Michael Moore and Miramax had to take that poster down. So you can see where there's a lot of fine points here, and again, no bright line rule where one person can absolutely see fair use. I think it's a very strong argument for it. The court ultimately ruled against it. Got a question?
Does it factor in that both, in this scenario, that both are in kind of the comedic genre versus previously where you've had the Vanity Fair mixed with the Naked Gun, that it's clearly kind of a parody of a serious thing? Would this be different if Men in Black was a drama, or does that not really factor into some of that?
Oh, that's interesting. I never thought about the case in that way. I guess what I would react is that the Men in Black poster is not in and of itself, I think, a funny poster. I mean, the movie itself is funny, and there's obviously a lot of comedy in that movie, but the poster itself seems to be taking itself fairly seriously. And so I think that gives it protection a little bit. I mean, leans obviously more to the protection. The court obviously didn't find that way. But I've never seen an analysis like that of a comedic original piece, and then can you parody a parody, right? And whether that would weaken a fair use argument because the existing thing was already funny. I don't know. I don't have any good examples either. Okay, so enough build up, right? So you have an example here of a court taking a poster down, and one where they ultimately said the poster won. And so now we go back to the Hulu deadbeat poster on the left and the ghost image on the right. So I'm going to play first, I'll play Paramount Pictures, the studio that made Ghosts. I'll play their attorney for a second. I think that their argument would be that, look, you copied exactly that scene. I mean, you've got the hands molding clay, the arms around each other. You're clearly, and like I said, I mean, the poster's openly evoking that image, but taking that, and I think if I'm Paramount, I say that taking is enough to be copyright infringement on the original work, and ultimately, I would probably, if I went back to like the bundle of rights, might say that's a derivative work. You're deriving this picture from the scene and the images of that. If I got a letter though from Paramount now as Hulu's attorney, here's my argument against it. I think it's transforming it, and the reason I say that is because, first of all, you're replacing the shirtless Patrick Swayze with a shirted Kal Penn. It is a comedy. There's a lot of comedic elements here to it. The budding bromance, the looks on their faces, replacing Demi Moore with a guy. The fact that they're not actually making a pot, they're making a fairly poorly made ghost face out of clay. All helps transform it, and it's not copying it because we want people who watched Ghost to say, oh, I liked Ghost in that romantic scene, maybe I'll watch Deadbeat. Instead, we're transforming it and adding to the dialogue by doing a parody, making it funny, and ultimately transforming the work. So, would you like to know how it turned out?
Sure.
We went with that poster, and to date, have not heard from Paramount, but ultimately feel pretty good about where we ended up on that. But you can see both sides, and it was not an easy call to arrive at.
Well, and both sides, both sides have arguments, and that's what AJ, just for the class, sort of laid out. AJ's obviously feels strongly that, if Paramount came knocking at the door, you feel pretty confident about your position.
Yes. Yeah. I like our odds.
All right. Okay. Let's move forward here. Okay. And AJ alluded this alluded to this earlier. I mean, if we look at the last time we had a major reform of our copyright laws, it was what, 1978?
Yep.
And you know, back then, you simply didn't have the digital age. What we had, for the most part, was still analog. I mean, when I was listening to a record, I was listening to, you know, to vinyl albums, and it was all, again, it was analog. And so digitization, okay, has really created a whole new set of issues, and it's complicated copyright protection. I think, AJ, you pointed out earlier to this concept about how do you divvy up the rights from that perspective, but you also have the question of piracy. Yeah. And needing to protect it. Maybe you want to explain to the class how digitizing information enables, if you will, or makes it easier, facilitates someone actually taking it.
Oh, absolutely. I mean, the digital age has helped us speed up transmission of information in all walks of life. But when you speed up the transmission of information, some of that information can be copyrighted works. And so, you know, in 1978, when the Copyright Act was enacted, you know, in order to steal an album, you had to walk into a record store, grab it, and stick it under your shirt and run. But in today's age, the stealing of an album and getting it without paying for it is as simple as, you know, going onto a website. Excuse me. So Napster had what's called a peer-to-peer network, where if you bought the CD, you broke it down to its digital MP3 files, you uploaded it to Napster and told it, you know, hey world, I have this album. And then if somebody wanted the album, they would just double click, and then you and anyone else who would also upload that album would send little pieces of the album to that person, and then suddenly, eventually, they would have all of the pieces to make the entire album in an MP3. And even though it took me longer to explain it, it's actually much quicker. And that can be applied to movies and TV shows on down the line, is instead of going into a Best Buy and, you know, stealing a DVD, or back then a VHS tape, now you can just, you know, go to a website or a peer-to-peer one. But those options are now out there, and there are pirates ready and willing to try to take as much as they can and then make their own profits off of it. Some of these pirate sites require subscription fees and to access all of their information. Some have banner ads. Some, quite frankly, make their money by sneaking a Trojan virus into the file. And so, yeah, you might get the file, or you actually might not get the file, depending on the site. But what you've really downloaded and launched onto your computer is a virus that they use down the line to make money off of you.
Okay. So I want to go back to some of the basics that we heard from Ms. Torres, and that is the types of infringement, right? I mean, so to go back to a point AJ just made, is when you have these outfits making digital information available for download on the internet, you have those folks, but then you have folks who are actually downloading it, and who's doing the infringement. And I guess we can come up with a lot of arguments as to who's, you know, whether it's direct infringement, indirect infringement, contributory infringement, and the like, or inducement. But you need to remember that when we talk about copyright infringement, and we'll touch on that later in the course, you know, it's not just somebody using, if you will, an unauthorized copy of something that's protected. The concept of infringement captures a whole swath of actors involved in that process, be they directly involved or be they indirectly involved. Okay, with that, I'm going to introduce you to the Digital Millennium Copyright Act. That was what, 1998? I want to say, and I'll come back to that.
Back when the millennium sounded like, you know, something very future forward looking and not.
Yep. It was 1998. But in 1998, when you had, digitization of information becoming more and more, of copyright protected information becoming more and more prevalent, Congress decided to step in and enact some additional measures that, a number of them judicially recognized, but Congress felt the need to just get this legislated so that there were no questions about it, and that there was some uniformity promoted here as well. And so if we think about the Digital Millennium Copyright Act, and I want to just go through some three basics, and AJ will expand on some of these things. The first part is, how do you deal with internet distribution channels, right? We've all heard of internet service providers, ISPs, and we've heard of the YouTubes of the world, where you basically have users who basically access these sites and download personal information, and you have others. How do you deal with outfits like that who are essential, if you will, to the process of communication, okay, and who may often unwittingly be participants in an illegal and unlawful piracy type action, copyright type action? And so part of the trick here is, again, it's a balancing act. How do you not get in the way of what these internet distribution channels provide that are critical to information exchange on the internet, yet on the other hand protect people from getting pirated? And AJ will go into how Congress tried to strike that balance a little bit. The second set, if you will, of key, and I actually want to focus on just those two. There's some others as well, but the anti-circumvention provisions, right? So what digital owners of digital information do often is institute protective measures to protect their digital information from getting pirated. And there's a whole swath of technology that deals with that. But what you did have, or still do have, are creative folks who find a way to circumvent those protections so as to get access to the information. And the law, the Digital Millennium Act, Copyright Act, makes that unlawful. You can't, and there are exceptions. There are some exceptions, and I can touch on those later. But for now, let's just focus on the rule. By and large, you can't do that. Okay. And by the way, the same is true of measures that are taken to protect analog information as well. There's some provisions to that effect as well. So those are two. There's some others in the act, but those are really the two, if you will, the most prevalent, the ones you hear about most often. And AJ, I want to turn it over to you on sort of this question of what do we do about internet service providers, sure, or the YouTubes of the world who who are in the business of facilitating information flow over the internet.
Right. So, and really, I hate to keep going back to that same example, but the Digital Millennium Copyright Act and that safe harbor provision that we're talking about really started with Napster. And because the record companies were frustrated in how do we deal with this, because we have all of these different users using all kinds of, or taking all kinds of albums, right and left. How do we cut off this faucet of piracy? And one of the ways that they tried to go about it is, well, let's not go after these users. Most of the time, we don't exactly know who they are. Let's go after the internet service providers. Let's go after the IP addresses, which is a way that online you can get an address for exactly where it is. Identify whether the internet service provider is Verizon or AT&T or whomever, and get a court order saying you have to stop Napster from running on as a service provider. And obviously the service providers fought back. And their defense was, look, if we do this, then you're going to cut off the the burgeoning internet, because you're now putting the obligation on us to monitor the content of what our users are doing on the internet. If suddenly these internet service providers are going to be liable for the copyright infringement. And again, by the 1978 Copyright Act, these old rules, the internet service providers were violating the copyright because it was their servers where these copies were being copied and distributed. And remember, those are two of the bundles of rights, is copy and distribute. So by the letter of the law, they were in trouble, but they said, let's take a larger view of this, and is this really how we want copyright law to operate? And so the Digital Millennium Copyright Act and the safe harbor provision was what was arranged. And to try to put a fairly 30,000-foot view of the safe harbor, what they say is that it's not incumbent on the internet service provider or distribution point, because it now is being applied to YouTube and Facebook Live and that kind of thing. But you don't have to know the content of it. But if you get a notice from a copyright holder that says we believe this is infringing, you have an obligation to take down the infringing content or cease the infringing activity. And if you do that, and if you have a method for responding relatively quickly, then you will not be found guilty of the copyright infringement. It's the end user that would be found guilty. So it solves the ISP's Napster problem, but who's really benefited is YouTube, because now YouTube doesn't have to police every single video that is posted onto YouTube. Instead, they rely on the Digital Millennium Copyright Act and its safe harbor. What you have to do is you have to have clearly posted, both with the Copyright Office and somewhere on your website, so typically it's in the terms of use, who your copyright agent is. And basically that's the contact information that a copyright holder can use to reach out directly to YouTube and say, I have a problem with this video, please take it down. And then YouTube has a process for taking down those videos. Yeah, you had a question.
Is there some kind of evaluation from the perspective of YouTube or whoever that might be as to whether the accused infringer is actually infringing, or it might be protected under some sort of parody or political commentary piece of that allows them to use the content?
Right. So the way that the safe harbor provision works is a little bit like Switzerland in World War II. Like, they're not supposed to get involved, and so the armies just kind of go back and forth among them. Hopefully that historical reference reaches some people. But the notion is, like, YouTube's not supposed to take a position. So what they end up doing is really facilitating a conversation between the copyright holder, the person who's saying, take this down, and the person who posted. So typically the way those rules work is that YouTube receives the complaint, and they will then kick it back to the person who posted it and says, we've gotten this complaint. Please explain to us basically what's going on. Are you actually the copyright holder, and is this completely bogus, or is there a defense to it here? Now, this is part where I will say there are a lot of exceptions to it, and part of this is YouTube is trying to be a good partner to all these content holders who do want to put their stuff on YouTube and feel safe doing so. So I would probably slightly editorialize, opinions are mine and mine only, but that YouTube is a little bit more content owner, copyright holder friendly on that because of trying to be good partners with those content holders. But for the most part, YouTube isn't supposed to get involved or adjudicate it. They do tend to just let it play out as a communication between the two. But their default is, especially with a copyright owner that they know and know has a wide portfolio of copyrights, will tend to take down even if the copyright, even if the poster, the person who uploaded that content claims fair use or other things.
Yeah, one thing I want to make clear to the class and anybody watching the video, when AJ is speaking here, I mean, from an education, conveying educational points here, he's speaking on his behalf. He works for Hulu, and he does a terrific job for them. But this isn't Hulu talking. This is AJ communicating some thoughts, other than what Hulu does generally and things like that.
Right. Did you want to talk about the DMCA case?
I did.
Great.
I did.
I think, yeah, because I think that plays in a bit to this question of the role that YouTube plays.
Do you mind doing that?
Oh, sure. So there's actually a famous case recently that went to the Ninth Circuit on these DMCA rules and the safe harbor. And it was the original video on YouTube it's been known as the dancing baby, and it's the dancing baby case, because a mom filmed her, let's say it's like 18-month or maybe 2-year-old baby dancing to music. And so she posts the video, it's hilarious, shares it with her friends, doesn't think anything about it. Then she gets a notice from YouTube that says, we have a copyright infringement and so we are taking down the video. So that's odd. The copyright infringement claim came from Universal Music Group, who owns the back catalog to Prince and his records and songs. And the baby was dancing to a Prince song. And so what happened is that Universal Music Group has a way in which they can scour YouTube for any songs that sound like Prince songs or any other rights holders that they have. And they had an automated means of then filling out the YouTube form and sending off the copyright infringement, which resulted in the person who posted it getting that notice and ultimately the video getting taken down. Well, she didn't think that was fair. She first fought it with YouTube, and YouTube said, that's the way the system works. And she said, that's not fair because I do think this is fair use, going back to an earlier topic. And what the court ultimately found was that she was actually right, is that they said that was fair use, and where they really scolded on Universal Music was this automated system. And that they said, if you're going to make a claim under the safe harbor and send a takedown to, using all the DMCA provisions, then you need to have a human look at that and make as part of your evaluation an evaluation for fair use. And I can say that court decision has made a difference in how we practice. Now, we were never as sophisticated as Universal Music and had those automated systems, but we now make sure that if we're going to do a DMCA takedown, if like some of our content pops up on YouTube or some other service that has the DMCA contact information, that we have one of our attorneys in our legal team look at it and consider fair use based on the holding of this ruling.
Okay, no, that's very helpful. And then AJ, I think, let me shift over here. Let's just and we'll get back on the takedown issues. I mean, Hulu's on both sides of this, right? I mean, sometimes you're in a situation where you do ask for a takedown, and sometimes you're in a situation where you're the subject of a takedown request.
Yeah, that's a great point. So we, like I said, if there's Hulu original content, we can be the ones making that takedown request from a YouTube or Vimeo. And so we do have a process for doing that at Hulu. But as a video distributor, we want to also take advantage of that safe harbor. And so my name is filed with the Copyright Office as Hulu's DMCA agent. And we have the contact information for me posted on our terms of use. And we do, every now and then get a notice takedown. And typically that's hey, you have a TV episode or a movie that's streaming on Hulu right now. I'm the copyright holder, and I believe, and this is part of the Copyright Act, or the Digital Millennium Copyright Act, you have to swear under penalty of perjury that what I'm saying is true, and so you need to take it down. And so then it's then my job to be the one responding, and unlike YouTube, we don't have an automated system. It's just old-fashioned me responding to that communication. But that's also part of what we do. So we are asking for the takedowns, but also receiving those takedown requests as well.
Okay. So we've been talking about piracy. What is piracy? Well, in a nutshell, it's the unauthorized copying of a copyrighted work. Downloading an app that allows you to strip the audio from a YouTube music video and store the audio file. Burning CDs. Uploading or downloading music into a P2P network. Paying a fee to join a file sharing network. transferring music over an instant messaging service, forwarding an email with a song attachment.
And if I can add one recent example that we're starting to see and deal with is, and this has come up mainly on live events, but Facebook living, something that you're watching. So, a court case that made a little bit of hay in my neck of the woods was before the Pacquiao-McGregor fight. Showtime went ahead and affirmatively went to the court and said, we know we're going to get these people who are live going to try to stream our stuff for free, taking away our revenue. So we want to get an affirmative injunction. What they did was they pointed out to websites that was basically advertising, hey, we're going to be live streaming. So this one was on Facebook Live, but we're going to be live streaming this. Come here to watch it, and affirmatively getting those sites taken down before the fight even happened because they were advertising they were going to pirate. And so you see all of this like live distribution coming into the realm of TV and movies as the new age of piracy.
Yeah, and when AJ uses the term an affirmative injunction, it's a little bit of a loaded word. And by that I mean it carries punch, because typically a court will issue an injunction after. Typically a party comes into court and asks a court to enjoin you from doing something that you've done, particularly when it comes to speech.
We touched on that a lot in advertising stuff. So, for example, if we had put that deadbeat poster out there and Paramount Pictures decided to sue, the first thing they would do is seek a preliminary injunction which says, "Hey, court, order Hulu to take down these posters right now."
Right, and the issue though with the affirmative stuff is that, I mean, this just goes to what AJ's talking about. Is this is the sort of the unusual circumstance where a court will actually step in and stop you from doing something before it has actually happened. That's not the rule, but it does happen in the practice or in what courts can do.
Yeah, I mean, the argument is that the fight's on, I believe it was a Saturday night. And like courts aren't open on Saturdays or Sundays. And so by the time I'm able to sit here, prove to you what happened, the damage is done. The horse is out of the barn. And so that typically is what you have to prove. You really have to show the court that not only do we know this damage is going to happen, but it's going to be so irreversible that the court, a court on Monday is going to take care of it. That's why we're here on Friday.
Right. Okay.
We got another question.
Yeah, it just, when I read that, you're forwarding an email with a song attachment is considered a form of piracy, I think what might be the most common, and I don't know that this falls under the definition of piracy, is that you've got, let's say, one master account holder for a Hulu account or a Netflix account, but you've got 7 different users who are sharing that password on various devices. Do you guys consider that part of the piracy issue that Hulu faces? Because undoubtedly that affects the bottom line for you guys as a business.
It definitely does. It's more of, I mean, I could see it being kind of construed as a piracy thing, but we certainly don't treat it that way. It tends to be more just a user-facing thing. Obviously, our preference would be we'd like every, not necessarily individual user, right? We have, families that share an account. We've set up now profiles so that mom and dad can watch their stuff, and little Timmy can watch his stuff, and mom and dad don't get cartoons suggested, and little Timmy doesn't get, comedies or dramas, more adult fare recommended to him. And so we obviously understand that within one household, there is, certainly account sharing, and like I said, our profiles kind of encourage that. But we don't really consider the account sharing a piracy, but we would sure love for everyone to have their own account, and really would like to discourage that practice as best we can.
But and there are gradations as well. I mean, if we're talking about a household situation where people in a household living under a single roof share the account, that's one thing. But if you have somebody, for example, who says, look, I'm going to have Hulu night at my house every Saturday night, and I'm going to project it on a big screen in my backyard, and I'm going to charge people to come in and see it, that's different.
That's different. That's an issue. And
Or invite the entire neighborhood to come in and use the same account for a fee.
Yeah.
I mean.
Oh yeah. And I mean, these are in my world, these are not hypotheticals. So yes, those are all issues. Yes. Absolutely. And it's really abusing our username and password system to avoid paying the subscription fee.
Right. Or unfairly making money off of having a subscription.
Absolutely. But there, we don't necessarily rely on copyright law. If we're hypothetically to go after those types of people, there I would actually first take a look at our terms of use, and that is the online contract that you kind of have to click agree to before you can start our service, because there are very clear limitations on what you can and can't do with your account, and commercial use of the account, especially trying to make a profit off of your password, basically, would be a clear violation of that term. But that would be a breach of contract.
And you have your options. I mean, copyright might be one avenue, but okay, you've got plenty of quivers in your arrow, or plenty of arrows in your quiver. All right, it's getting late. Let's take a step back. How's the music industry reacting to to the mischief, if you will, out there because of easier access to digital information? Well, one of the things you're seeing is this concept, and AJ touched on it when we started the course today, which is iTunes. Sort of this: if you can't beat them, join them. And if folks are going to turn to the internet, and they are going to be downloading music from the internet on their own personal devices, let's create a system that enables folks to do that, albeit for a fee. And iTunes will probably offers a host of other services and technologies that really facilitate that process, and in a sense probably make it a lot easier than going about it in an unauthorized way. So that's certainly one way that the music industry's dealing with it. What we're also seeing is more reliance on live shows, and that's a trend that we see out there as well. But certainly, sort of this iTunes concept is really key. But this sort of brings us back full circle to the film industry and what Hulu's about.
Yeah, I mean, that is essentially the getting ahead of that digital transition is really what Hulu is based on, right? Let's go back to that that original graphic I showed you of the NBC and Fox getting together. I mean, what they saw, what was happening in the music industry, and instead of having an iTunes and Apple step in and be that facilitator, or later on Spotify, what if the TV studios themselves got in front of that, paired together with a couple of other TV studios, and became that digital distribution point? And that's really the function that Hulu provided. So for music, wouldn't Universal Music Group and all the other record labels have loved to have been ahead of Napster and come up with a digital distribution platform so that they don't have to pay a percentage of all their sales to Apple that are on iTunes, or lose revenue to Spotify, who's providing it in their own way? And that's really where that's how Hulu got created, and in part the role that Hulu continues to play today.
Right. And so the notion here, again, and this is a question that I put to AJ earlier, which is, look, you have HBO on demand, you have Stars on demand, you have a bunch of individual on demands out there, and what Hulu really brings to the table is consolidating all of that and making it a better user experience.
Yeah, that's what we're trying to do. And you've got NBC involved, you've got ABC, you've got Fox, you've got Time Warner and those Turner channels, but then we also offer HBO, Showtime, and it's all on that one app. And so I think you're probably going to see, if I speculate a little bit into my industry, a lot more people trying to do their own standalone apps because they're kind of convinced that we've got the goods. I mean, our stuff is the best, and so we're going to have cord cutters, but they're still going to want their X product, and so they're going to come and subscribe. So I think you're going to see a ballooning of a lot more apps following in that CBS example that I gave. But then I think there's going to be market pushback, and you're going to try to see a little bit more consolidation to, well, I would hope Hulu, but maybe a Hulu competitor in the future where people have consolidated 3 or 4 content into one app for ease of the user experience. Because the last thing you want to do when you sit down after a long day is then try to figure out which of your 15 apps you want to open up. Instead, just open up Hulu. It's very simple. There, I'll end it on a sales pitch. I'll see if the Nike guys can sell shoes next week.
AJ, thank you very much.
My pleasure.
That was just absolutely terrific for the class. Appreciate it, and we're going to be touching on more copyright stuff as the course progresses, and you'll probably be getting a call from me inviting you to show up live in front of our students if you have some time.
Great.
Because there is absolutely no doubt in my mind that your presentation, that they enjoyed it, but number 2, probably have a lot of questions that they'd like to throw your way. So if you have time, I'm not asking you to commit. Okay, one point early on, I think I mentioned when I was talking about ANDA, and I may have misspoken. I may have said like the generics get 180 month or 18 month or something like that exclusivity to duopoly at the back end. If I said that, I didn't mean that. I meant 180 days. Just go back to the original video. With that, good night.